Okay, let's talk about Planned Parenthood of Southeastern Pennsylvania against Casey, which we'll just call the Casey case for short to keep that manageable. Obviously, this is a case that comes to us out of Pennsylvania, and I want to start my discussion of this by mentioning analogical reasoning. I'm a big fan of that. It is underrated and underused. Analogical as in analog, as in comparison. Sometimes as lawyers we run out of rules to apply, and when we run out of rules to apply, we have to default to something else to try to discern what an outcome or try to argue for an outcome in a case. Analogical reasoning means that instead of looking to a case for the rule, you're looking to a case for what happened in the case to compare your case to that case. In these abortion cases, all we have are very amorphous, vague tests to apply, as you know. The undue burden standard is defined as a substantial obstacle, which, as I mentioned in the prior video, is not very helpful. It's still very vague in general. And in Hellerstedt, the court said, well, that means undue burden is a balancing test. Well, balancing tests, as you know, can be manipulated one way or another. Again, they're not elemental, they're not categorical, they're very flexible. It's hard to predict an outcome under a balancing test. You can pretty much use a balancing test to reach whatever result you want. So, when we think about or study, discuss the Casey case, the important thing out of Casey, in addition to obviously knowing the rule, the magic words, is to look at the 5 different components of the Pennsylvania law that the court dealt with, and to look at what the court did with each one of those 5 components of the Pennsylvania law that were challenged in the Casey case. As a lawyer, what you would do if you're challenging a state law, a state abortion restriction, you would point to the provision or provisions throughout Supreme Court history, the laws that have been struck down, and argue that the law that I'm challenging is just like the laws that have been struck down in these cases, including Casey. As you know, there's only one part of the Pennsylvania law that was struck down in Casey, but still that's instructive. On the other hand, if you're the government trying to defend an abortion restriction, you're going to argue, oh, this is just like the many restrictions and regulations and laws that have been upheld by courts as not being an undue burden on a woman's right to choose to terminate a pregnancy. You know, I tell this story to every class, so you might have heard this in Common Law 1, this spiel about analogical reasoning, but it's back and it's important. When I was clerking for the Michigan Court of Appeals as a research attorney, which was their fancy language for judicial clerk, sometimes you would be instructed to go and find a whole bunch of cases on a certain topic. And I ask you, how many cases, you say I'm looking at a Michigan interpretation of a Michigan statute. How many Michigan Supreme Court cases do I need to tell me what the rule is? The answer to that is 1. I need 1 case to tell me what the rule is. So why would judges or research supervisors be telling research attorneys, go and find me 25 cases on this? The reason for that, obviously, is that we're not looking for the rule. I don't need 25 different cases to tell me what the rule is. I need 25 different cases to show me how the rule has been applied in certain circumstances. This is why I award credit on exams for discussing the facts of cases. That doesn't mean you have to know case names. It means that you're using a lawyering skill that people don't use enough, especially in law school. It is very rare on an exam for me to see somebody discussing the facts of a case and appropriately, not just willy-nilly, because I see this too, right? Oh, he wants us to talk about cases, so somebody will just throw a case in there, a case that has nothing to do with what the fact pattern is. And I'm talking about intelligently, right? Comparing the facts of our case, our fact pattern, to the facts of cases that you've studied. Relevant comparisons. So let's talk about, out of the Casey case, 5 different examples that you can use when you're tackling some kind of a new fact pattern about a state law, usually it's going to be a state law, that burdens a woman's right, or arguably at least burdens a woman's right to terminate a pregnancy. Okay, as I mentioned, there are 5 different provisions of the law that are at issue. The first is routine informed consent. Now, in a companion case to Roe versus Wade, in a case called Doe, the Supreme Court looked at state laws that did things like impose special accreditation requirements on facilities that are going to perform abortions. There was, in one case, a hospital abortion committee that would decide whether an abortion was advisable, comprised of who knows who. And the court in that case said, look, we want to see states treating abortion procedures like similar medical procedures. If you have one set of rules for other medical procedures and one set of rules for abortion, when medically speaking they are compatible, then we're going to be left to conclude that something is up here. That what you're really doing here is trying to make it harder for a woman to have an abortion rather than trying to achieve some kind of positive medical outcome. So with that in mind, think about routine informed consent. Routine informed consent is something that, and any one of us who's gone to the dentist to have a tooth pulled, to have a hangnail removed, I mean anything. Anything you do, that's the form, right? They give you the clipboard, and they give you the paper on top of the clipboard, and you have to sign it, and it tells you all the terrible things that could happen while you're at the medical office, including, you know, if you're getting a tooth pulled, you could die. So we've all seen that. Is that an obstacle? Now be careful about this. Whenever I ask this in a live class, I say, is that an obstacle? This requirement that you sign an informed consent form, that you look at it and sign it? And people usually rush to say, oh no, that's not a burden. Well, you're wrong. It is a burden. Okay. The point is that in Casey, a law isn't unconstitutional because it's a burden. A burden is just a hoop you have to jump through. And yeah, so you hand me the clipboard, I have to look at it, and I have to sign it. That's a hoop I have to jump through before whatever procedure can be performed. So is it a burden? Is it an obstacle? Yes, it's a burden, it's an obstacle. But to get to what I was about to say, the rule under Casey isn't that a burden is unconstitutional, it is that a substantial burden, a substantial obstacle, or an undue burden. So we're trying to figure out whether it's too big of a burden. Of course, the court says, look, we want abortion procedures to be treated the same, generally speaking, as like medical procedures, and informed consent is a part of just about any medical procedure. No problem here. This is not an undue burden. I think that one was pretty easy. The next one's not so easy. Pennsylvania law also requires, after informed consent, that the woman wait 24 hours to have an abortion. So there's a 24-hour wait. Now, is that a burden? Of course it's a burden. It's an obstacle. Is it an undue burden or a substantial obstacle? Well, of course that depends who you ask. The court says, no, it's not. The court in Casey and again in Hellerstedt, which we'll talk about in another video, has recognized that although abortions are medical procedures, nonetheless, the state has some interest all through the term of the pregnancy to safeguard the interests of the unborn. So it's interesting dichotomy. On the one hand, the court says we want you to treat this procedure like you would treat any similar medical procedure. On the other hand, the court every now and then gives a little nod to the state and says, yeah, but this is a little different. There's more at stake. There are more interests in play, as I keep saying. So with that in mind, the court says, you know, a 24-hour wait for somebody to, essentially to sleep on it after you've been given the information you need, and to weigh the consequences and consider those. And again, I know this is controversial, so I'm not advocating for the court's position. I'm just saying this is what the court said. The court said 24-hour wait under these circumstances, given the nature of the procedure, is not an undue burden. Now, what you see on an exam, if you get an essay question on abortion, if there is a waiting period in the fact pattern, it's not going to be 24 hours because that's too easy. The court already said a 24-hour wait is probably constitutional. Now, there may be circumstances under which it wouldn't be. If you have a huge state where there's only one abortion clinic, right? People have to drive 600 miles to get to the clinic and pay for overnight accommodations, and there may be circumstances where, as applied, it would be unconstitutional. But the court says, as a general matter, we don't see a constitutional problem with a 24-hour wait. What you would see on an exam would be something like, what, a 72-hour waiting period. So, analogical reasoning, what do you do with that? Don't worry about the right answer, worry about making the appropriate comparisons. You would say, if you're, look at either side here. If you're challenging the law, you would say that 72 hours, I'm no mathematician, but I can do this math. 72 hours is 3 days, whereas 24 hours is 1. So if I'm challenging the law, I'll make it sound like this. This law imposes 3 times the waiting period that was acceptable to the court in Casey. On the other hand, if I'm the state, I say what? I say 3 days, 1 day, 24 hours, 72 hours, what's the difference? 72 hours is a long weekend. So instead of taking a night to think about it, take a long weekend to think about it. No big deal. Now, who's going to win? Doesn't matter. The point is that you know that the facts out of Casey involved a 24-hour waiting period, and that the facts in your fact pattern involve a 72-hour waiting period. That 72 hours is longer than 24 hours, but it's still not a month. One of the things, obviously, a judge is going to be concerned about, if a judge is applying these rules, is how the waiting period might affect the viability of the fetus, right? If you start asking a woman to wait for a week, 2 weeks, a month, now there's a significant possibility that during that time, the fetus will go from pre-viable to viable. All right, the third, this is the last one I'll talk about in this video. The third state law provision that's at issue in Casey is routine record keeping. You've all heard a lot lately about the CDC, the Centers for Disease Control at the federal level. States have similar types of agencies, and they keep records. And abortion, like virtually any medical procedure, is a public health issue. So states, when they make policy, have to have public health data. The court sees nothing suspicious about collecting routine data. Medical facilities do it all the time, and then report what they know to the government. Now, this is not to say that medical facilities should be spying on patients and turning over personal medical information to the state. That could actually pose quite some problems. However, if you're just talking about, we need demographic information, we need age information, we need as much information as we can of how unwanted pregnancies occur, so that we can prevent unwanted pregnancies. If that's what you're doing, well, there's a public health reason for that. That's routine record keeping, and that kind of information can be collected and shared. Now, again, what you look for possibly in an exam fact pattern would be different types of facts. What if a state passed a law saying, you're going to collect, you're the medical facility, the abortion clinic, you must collect the woman's name, personal phone number, personal email address, real address, and all of that has to be loaded onto a publicly searchable website. Okay, if that's the kind of record keeping that's required, then on an exam you wouldn't say, oh well, this is just like the record keeping in Casey. No, the record keeping in Casey was routine record keeping. There was no indication in the Casey case that the information was being used by the state on some kind of a forum to do public shaming. So in the next video I'm going to talk about the notice and consent provisions in the Pennsylvania law. There are 2 of them, one for minors and one for spouses, and we'll see how the court dealt with both of those, but that's enough for this particular video.